Way.
Good afternoon, everybody, and thank you very much for coming to the recent professional development event on wills and trusts. Right now, everybody is going to be muted for now until the end. If you have questions, please put them in the chat. Mary Beth will compile them all, and then we'll go over them at the very end. We also have a candidate for the PERS board that will give a small presentation at the end of this as well. I'm going to introduce everybody right now. So we will start off with our business reps, and we'll start off with Zeb.
Good afternoon, everyone. Thank you so much for coming out. My name is Zeb Feldman, CEMA OE3 business agent. Pleasure to be here.
And Jonathan.
Afternoon, everyone. My name is Jonathan Brown. I'm one of your four SEMA OE3 business agents. My areas are primarily Monterey and Santa Cruz County. Happy to be with you this afternoon.
Thank you. We also have Adam Cole and Lawrence Sue, who are both out at regional for the what the heck was it the
Press conference.
press conference. Thank you. Yes,
Yes.
they're out there today. Dolores, our president, are you here today?
I believe she's also at that event.
Yeah, he's
Okay.
up to the event.
Carla Collins, the senior vice president. Not here. Okay. Mary Beth Rogers, the SEMA secretary.
Hey, everybody. I'm Mary Beth Rogers. I work at the Social Services Agency as a management analyst, and I am proud to serve as your SEMA Executive Board Secretary.
I am Robin Rivas Romano. I am the I am the vice president on the executive board of SEMA. I work at the Social Services Agency in administration. And now we have Andrew.
I see Carla
Hello,
Torres.
I'm Andrew
I'm sorry,
Crockett.
not
I
wrong
serve
company.
as treasurer for CEMA. I am a CPA working over at Valley Medical Center.
Thank you. Mary Snow.
I believe that's all the board that's present, Robin.
Great.
I do see Donna.
Okay. So that's the board. Andrew, can you please introduce Alex?
With pleasure.
Thank you.
Alex is our representative with LPL, our investment firm, and he has been fulfilling his fiduciary duty to CEMA by connecting us with the experts we have assembled here today. Alex, would you like to give a brief summary of them, or would you like me to proceed to do so?
Feel free to go ahead in general. It's a real pleasure to invite Victoria Raymond, Zachary Raymond, and Drew Tolvend.
Yes, Victoria, she is has a wealth of experience in estate planning and serves clients mostly here in San Jose, Santa Cruz, and Sacramento. And she is dedicated to helping people establish meaningful legacies through personalized estate plans. And we are pleased to have her. Zachary has over a decade of experience in finance, specializing in financial strategies and financial literacy for his clients. And Drew Torvend, a financial advisor with over 20 years experience and also operates with LPL, based out of Los Gatos. Is there anything that any of you would like to add to your basic introductions before we hit the road on this?
If I may, Andrew.
Mm-hmm.
First off, this particular team has just exceptional credentials and they have your best interests at heart. Everyone has been curated for this particular presentation and others. And we look forward to not only Victoria presenting on wills and estates, but if there are additional topics that come up or come to mind, we are well versed on hundreds of different topics that we're more than happy to introduce at later meetings. I will tell you that in my experience with Drew, Drew is a man of his word. He comes highly recommended. He has a very extensive client base, as does Zachary. And Victoria is one of the top estate planning attorneys, certainly in the county, if not the state and country. And with that, I'll pass the mic back to you.
We have two people that have just joined us. One of them is Carl Carr, who works for OE3. Carl, would you like to introduce yourself?
Sure, thank you. My name is Carl Carr. I'm the Public Employees Division Director here covering all the public employees in Northern California and Northern Nevada. Thank you for having me.
Thank you. And Carla Collins, the Senior Vice President, is here as well. Carla, would you like to introduce yourself?
Hi, thank you. Thank you so much, Robin. I'm Carla Collins. I'm in the County Exec's Division of Equity and Social Justice, Office of Gender-Based Violence Prevention, but most proud to be your Senior Vice President.
Thank you. All right, Alex, we'll turn it over to you.
Victoria is going to be giving us a presentation on wills and trusts. As everyone in the executive team knows, this is a topic of discussion which has been on the docket for some months. The genesis of this particular call was there was a need that was perceived by CEMA members for wills, trusts, general estate planning, and an emphasis on domestic partnerships as well as special needs trusts.
Yeah.
And it didn't take very long to find Victoria. She is going to be giving us a thumbnail sketch on this topic. As I'm sure everyone can appreciate, this is a fairly pithy conversation that can go in many particular directions. We do invite questions. And if there are additional questions after this presentation, certainly feel free to contact either Victoria, Zachary, Drew, or myself, and we'll be happy to go ahead and help you on an individual basis. And with that, I'll pass the mic over to Victoria to start her stuff. Victoria?
Perfect. So I'm going to share the presentation here. Just a couple of things for Copenbarger in particular. Most of what we talk about today, there are more extensive free resources and webinars on our website. So if anything does strike a chord where you need more information, you guys are welcome to take advantage of those free resources. It's just copenbarger.com. Anyone can access them. As far as domestic partnerships versus other married couples, things like that, the good news is with estate planning, married domestic partner, just even in a long-term relationship that is not government legal, so to speak, but is a long-term relationship, we can plan for it, is the great news. So jumping in a little bit about Copenbarger as a background and part of why I'm specifically here, we take quality extremely seriously. You can throw a rock and hit 50 different estate planners, but quality is not a given, unfortunately. And when we're talking estate planning, investment planning, retirement planning, you really want to make sure it is quality. Because unfortunately, you often do not know the cost of an estate plan until you actually need it. Now, not only do we do estate planning, we do business and tax planning. So if you have rental properties, you've started your own business at some point, things like that, we can also address a lot of those questions in-house. We have an estate administration department. So if somebody passes away, we can also then walk alongside whoever is going to be wrapping things up and help take a lot of the burden off of their plate. And then we also do estate litigation. The estate litigation, we frankly hope you never need. We're hoping that everything we set up is to avoid court and that you never have the chance to work with Elaine. But if something's in court, we absolutely love having Elaine. She is a phenomenal litigation attorney. For questions, please feel free to throw them in the chat. I will either address them as they come in if they're relevant to the slide or do some Q&A at the end also.
Tara, we're going to have somebody list all the questions and then we'll ask them all at the end, okay?
Perfect.
Thank you. Thank you.
Our staff is one of the largest as well, so we have a huge ability to help many, many, many clients. We are able to be pretty darn efficient, get questions answered in a timely manner, and we really could only do that because of this incredible staff. We have offices all over the state, so if you move, if you need help in a different location, we're probably there also. So we have quite an operation going. But diving into the basics. So most people don't want to talk about estate planning. It's a drier topic. It can frankly be a sad topic, but it is a crucial thing to make sure you plan for before you actually need it. So when we're talking estate planning, it's a comprehensive set of documents. There is not one document that can do a full scope of protection. You really do end up needing typically 3, 4, sometimes more documents to really ensure that you are fully protected. The first one that every single person over 18 needs is an advanced healthcare directive. The second you turn 18, no one has an automatic right to make your medical decisions. So if you're married, a spouse doesn't have an automatic right. Your parents don't. Your children don't. You have to be able to have either given verbal authority to a physician or have it in writing if you no longer have the ability to give that verbal authority. Without it, again, nobody legally can even know what room of the hospital that you are in. The other thing is if you already have a healthcare directive, you need to make sure it was done after 2004. Directives done pre-2004 are no longer valid. The reason is HIPAA laws changed in 2004, and there's specific language that has to be in them in order to comply with what the physicians need. The other point with these is you want to keep them up to date. So if you have one in place, we recommend clients see us every 3 to 5 years just to do a review. Not because we expect it's changing all the time, but especially if you are in a position where you can't make your own medical decisions, you're most likely vulnerable at that point. And we want to ensure that the people or person named is who you would actually, in fact, want to make those medical decisions. Fourth point on this is you want it to be comprehensive. You can, for estate planning documents, find free pretty much anywhere you look. But the problem is they often cut quality and they cut that comprehension. One of the things that we want to make sure is addressed is things like, do you want life support at the end of your life? That's a question that not only do we want to make sure you still have the autonomy to have pre-decided, even if you can't communicate, it's also a huge weight off the person who's making that decision if you've predetermined whether or not you want something like life support. So for the healthcare, it seems like such a simple document, but it's one of the most profound because, again, you're in a vulnerable state if this thing. The next one that we say everyone over 18 needs is a durable or financial power of attorney. This comes into effect if you are, again, incapacitated temporarily or permanently. So if you're recovering from a procedure and you can't sign checks or make financial decisions, if you have Alzheimer's or a stroke and you permanently are unable to make financial decisions, again, you have to have in writing who has the authority to manage your finances. A lot of people assume their spouse can manage everything unilaterally if they are no longer able. But thinking about retirement accounts, for example, you're the sole owner on that account. If you're incapacitated and don't have a valid power of attorney, your spouse is typically only a beneficiary. They're not a manager legally on the account. So you have to have something in place to let them do anything on your behalf, not just be limited to what they have ownership of. And then what if you're not married or something happens to your spouse? You absolutely need this in place because basically no one else has, again, an automatic right. If you already have a financial power of attorney, most financial institutions are considering these documents stale if they are older than 5 years old. We've had clients who have had these rejected time and time again if they're outdated, in part because they're reacting to still COVID and incapacity issues, and so trying to combat financial fraud and elder abuse. Now, not in all circumstances, but it is something we're recommending be updated every 5 years at this point to ensure you don't run into any red tape when you absolutely need this document. Part of the other reason these first two are so imperative is if you don't have the ability to give the permission any longer due to incapacity and it is not in writing, unfortunately, the court is the only way that you can get somebody appointed to make medical or financial decisions. And it is a nightmare to deal with conservatorships. They take a long time, they are expensive, and again, they're needed when you're vulnerable. So it is not the time you want to be dealing with the court. So if you take nothing else away today, make sure you have those first two documents in place and up to date. Then we talk about, do you need a will or do you need a trust? Now, people who need wills, you do not own a piece of property and you have less than $184,000. If you have a piece of property or you have more than that 184,000, a will is not going to be enough to protect your estate from court after you pass away. If you are under those thresholds, we can absolutely discuss wills. Now, regardless of those first two, if you have any minor children, you still do need a will. The purpose for that is to name guardians of your minor children at that point. So if you have any minors, you need a will no matter what else we do. But if you asset-wise are over these thresholds, we need to start talking about doing a trust. Again, the issue with a will is court. So basically, the probate court has said if you have a piece of property or more than $184,000, your will is too basic. It did not answer enough questions. The court now has to step in. The other issue is with trust planning, we can do tax planning. Now, when we're talking about taxes, it's not just for the uber wealthy. This could be property tax protection when you've passed, capital gains trust protection. Sometimes it's income trust or income tax protection when you're alive, but there are a slew of different taxes that hit both while we're alive and then unfortunately after we've passed. And with proper planning, you can either reduce or in a lot of cases completely eliminate unnecessary taxes. We have to pay our legal taxes, but you should not have to pay unnecessary taxes where there's a back door that could have been taken advantage of. So again, with proper planning, we can reduce those liabilities. As I mentioned with conservatorships in the court, probate is very similar. It's very expensive, it takes a frightening amount of time, and the control is with the court at that point. So anywhere we can avoid the court and keep the control in your hands or your family's hands, we absolutely want to do it. This is a quick cost analysis of if there was a probate in San Jose of what it would cost for a median home value of about 1.4 million to go through probate. Now, it's really important to note that probate looks at the gross value of your property, not what your equity is. So if the property can be sold for 1.4 million, they do not care if you only have equity of 100,000. The fee is put on the entirety of the value of the property. So court, as you can, I'm sure, imagine, really ends up depleting people's estates. The other thing you'll note is the attorney fee line is front and center, and it is a huge number. Well, why would I be sitting here telling you to avoid that? Most attorneys you would think would want you to pay that. Two things. One, we do not set our own fees. This is set by the court. So the court is who dictates how expensive this probate will be. The second thing is Koppenbarger was founded to take care of our clients. Probate is not the way to take care of clients. Doing proper estate planning is. This is absolutely an avoidable fee. It is absolutely an avoidable nightmare. So that's what we're now going to talk about. So that's the good news. You don't have to deal with the court unless you have people who truly just want to fight when you're gone. It does happen, but we will do everything in our power to cut that out. That is where we start to talk about trusts. Basically, trusts are answering all of the different questions that the court said a will would not if you own property or have more than that $184,000. You get to set all of the terms. You say, if I can't manage, who will do so on my behalf? You get to say who's going to inherit and when they inherit and how they inherit. Because let's use the example of you have 3 kids. It doesn't necessarily mean you want each one to inherit the exact same way or even the same amount. There can be issues where if they're minors, they're special needs, you are concerned about if they get divorced, how to protect their inheritance. There are a ton of different reasons. Just because you've got 3 kids doesn't necessarily, again, mean you want it split the identical way across the board. So we can build all of these protections into the trust itself. And then I mentioned tax planning. So one of the big issues right now is we're under Proposition 19. If you don't know what Prop 19 is, it essentially eliminated property tax benefits when somebody inherits a piece of property. It's been a huge one that we've looked to address and try to capture benefits that used to exist. The new law says if it's a secondary piece of property that transfers, it will be reassessed, period, end of story. So when somebody inherits a piece of property that's a rental, a piece of land, a business, the property tax will be reassessed. Primary residences can have an exception. If you have a primary residence that becomes your child's primary residence, they can keep your full property tax base, what you pay, rather than what the new rate would be. But I'm going to use the scenario again where if you have 3 children, if right now you have an estate plan that says my 3 kids are going to inherit my property equally, you die, they inherit it, and child 1 says, hey, I'd love to live in the property. Can I buy you guys out? And child 2 and 3, they say, yep, no problem. Now you have what's called a child-to-child transfer. 2/3 of that property get reassessed for property tax purposes. But you could put language into your trust that gives the child 1 the option to do that before a distribution was made. So all 3 still walk away with an equal amount, but child 1 could keep your full property tax base instead of having reassessment. That is just one example of the ways that with tax law and things as they change, how we can help preserve either a lower tax basis or at least give more options instead of there being no option after you are gone. Everything we seek to do is keep the control with you, with your family, and again, maximize benefits and reduce any liabilities. Now, even if you have a trust, we also do create a will alongside it. The reason for this is when you set up a trust, certain assets need to actually be titled in the name of the trust. Typically, that's your pieces of property, checking accounts, savings accounts, and non-retirement investment accounts. If this step is not done and it's in your name alone when you die, ordinarily the court still gets to control that asset. However, we've created this will to say, no, court, you have to give it back to my trust and let my trust control the asset. So it's a safety net, basically, to make sure. Now, I know I am throwing a slew of information. We often say this is like drinking from a fire hose. Again, we have webinars on this information, and in consultations, we break this down even further and get more one-on-one with you. Now, digital assets are a huge part of the discussion at this point. Social media accounts, your photos, things that are on our technology devices often are lost after someone passes because they didn't set up somebody to take it over when they're gone. So one thing to note is on Androids and Apple, you can set what is called a legacy contact. This is essentially somebody who, if you passed away, could access your accounts in your phone so they can recover photos, they can have your contact list for a funeral, for example, they can let people know you've passed. So I strongly recommend people set this legacy contact on their phones. The other thing is cryptocurrency has become a very large part of some people's asset base. Cryptocurrency, though, is not treated like your other assets in almost all circumstances. It is considered personal property rather than a bank asset. So it is imperative for cryptocurrency that if you have one of those codes, keys, chains, whatever it is to access that account, that you have put that in a place somebody else can get to after you have passed. Because if not, there are really no recovery options for a lot of these different accounts. And so it can be a completely lost asset if you haven't set up something that, again, someone can access. Questions on this stuff, again, we're more than happy to help address. Special needs trust. So this is something you'll notice there's a little QR code at the bottom of this slide. That means that if you scan that, it'll take you to a webinar specifically on special needs planning. This is one of the most misunderstood areas of estate planning. Most people believe that if they leave an inheritance to a special needs beneficiary, that beneficiary will absolutely lose all government resources they may otherwise have. But with proper planning, you can leave them an inheritance that can be managed and used for their benefit without triggering them losing their benefits. So again, there's ways to make sure that they get the best of both worlds. You set it up, they get the inheritance, but again, they keep their benefits. One of the issues we often see here is if people don't want to do the planning, they say, okay, I'll just leave it to my other child and task them with taking care of my special needs beneficiary. We have seen horror situations with this where the child that the money is left to is now legally that child's, and they do not use it to take care of their special needs sibling. And there is nothing legally that can be done to address this. It has happened way too many times. So instead, again, we recommend putting it into a trust for their benefit where somebody has a legal mandate and duty to manage it on that person's behalf and use it for their benefit rather than them being able to take it and use it for their own benefit. Again, I would recommend if you have more questions on this, use that QR code, look on our website. That webinar goes into even more detail on this topic. And then the other one is your adult children. So if you had minors, they're now adults. One of the issues is they now have their own problems, possibly. So this could be they got married and divorced. They were in a car accident that's completely their fault. One of the things that we can set up is an inheritance trust protection that says, hey, after my adult child receives their inheritance, it's going to actually go into a trust for their benefit. That trust then protects their inheritance from divorce, lawsuits, creditors, bankruptcy, and the IRS. So if, again, they're in a car accident, they go through a divorce, their own estate might be subject to whatever's going on, but the inheritance is protected and preserved. So these are just a couple of things that we end up talking about. But again, estate planning is easy but complex. It really depends on each family's circumstance. But I will say, I pride myself in Koppenberger as a whole. We try to make this as ascertainable, understandable, and break it down as much as possible. Because what we hate to hear from people who've worked with other attorneys is, hey, I set up an estate plan, but I don't really know what I signed. We want to make sure you get it. And if you don't, keep asking questions. But if you go beyond just the base level need of estate planning, again, we can do a ton of different advanced planning options. You'll note on here pet planning. So at least for my husband and I, pets are part of our family. If we need to provide for your pets, we are here to do that. If we're concerned about if I die and my spouse remarries, how do I protect my half of the estate? We can do that. Rental properties. You have grandchildren who you want to provide education funds for. All of these things we can help either on the estate planning side alone or in conjunction with your financial planners. Again, you want to work with an estate planner who also works with other professionals who do what we don't. So that's your financial planners, your CPAs, people who go above and beyond just what's right in front of us. So that's a very quick intro to Koppenberger. We have actually been around since 1979. We have been doing this for a while, and we have been at the top of the field for the entire time. So if you are concerned about why choose us over, again, the 50 that you could chuck a rock and hit, it's the quality, it's the continuing education, and it's these education events we do for people. We do webinars all year long that are free, client seminars all year long that are free, incoming prospect webinars and seminars that are free, because we know that this is a very, very complex topic. So our job is to take the complex and make it understandable. So again, if you guys have any questions on any of this, please do not hesitate to reach out. Also, for anybody that references that they were on this call, we're offering complimentary consultations. So we are happy to meet with anyone on this call to help answer these questions and get you to whatever the next phase will be for your estate planning or financial planning journey. All right, very quick, but I am happy to take any questions that came in.
Victoria, there are some questions. And first off, thank you very much. That was a very succinct and to the point presentation. Congratulations. That's a lot of ground that you covered there. And
Great.
you did a great job.
Yeah. Mary Beth, would you like to start with the questions?
Yes, sure. Can everybody hear me?
Yep.
Okay. So there's kind of a group of 3 questions that came in right at the beginning on one of the very, very early topics. I'll read all 3 of those. If someone does not have durable power of attorney, they are single and they are incapacitated due to dementia, in parentheses. Is there anything that can be done now? Number 2 there is, and how do forms get updated every 5 years if someone is incapacitated? And then number 3 in that group is, can these forms please be made available to us? But because you mentioned that there are forms like available all over the place, so I'm not sure exactly where that question is going.
I'll work backwards for the, can the forms be made available? If it's our legal document, we end up drafting them and doing it for you. When I say there's ones available, you can find free options online. You just Google the term, but I typically recommend staying away from them because they're very simple and they don't really address the full scope of what someone could need. But if you have more questions on that piece, happy to answer them. If someone does not have a durable power of attorney, they're whether married or single, and they're incapacitated, unfortunately, a conservatorship is where we have to turn. It's getting the court to step in and appoint somebody to manage the financial matters and the scope of what that would be. So it's not ideal, but there are still options. So if you're in that circumstance, happy to have that conversation as well. How do you get the forms updated every 5 years? If someone is incapacitated, you can't. And so it's why we recommend people see us more frequently to try to get ahead of incapacity. If that situation occurs, banks will sometimes accept them just on their face. Sometimes they will accept them if we send a letter basically certifying here's who the person is, we've worked with them, now this is the circumstance. And sometimes they just flat won't accept it and the court gets back involved. Banks get to set their own policies. It's not based in law, so it's really unfortunately in their control at that point.
There was a follow-on question. Should a trust beneficiary be the child's trust? Is this better? Should the trust beneficiary be a child's trust?
So it would depend on the age of your child. You can do child trust provisions. If they're an adult, you can do adult trust provisions. This, I would argue, is more of a consultation question because I would need significantly more background to give an actual what's better in your context. So it would depend on the circumstance, though.
We have another question. If my spouse and I have established a revocable living trust, and one of us passes away, does the surviving spouse have the authority to modify the terms of the trust?
It depends on the type of revocable trust you have. So we do 2 primary types of revocable trusts. One does allow the surviving spouse, to have full authority. The other limits their authority to only modifying their portion of the estate plan. So it would depend on the type of revocable trust you have established and what the trust allows or restricts. We're happy, if you already have trusts, we're happy to take a look at them and help answer those questions in the consultations as well.
And then we have a follow-on question from that. Can you have something in the living trust that dictates that children will get a certain percentage or amount that would preclude a surviving spouse from expending all the funds in the trust and or giving all the other assets to a future spouse?
Absolutely. You can build terms about remarriage protection, child protection if you've gone. There are a ton of different options to make sure that your portion at least will go to your kids. We can do triggering events where if you get remarried, if the new spouse doesn't sign away their right to your part, it triggers a distribution. There's a ton that we could do to build that.
And then there is another question on retirement accounts, and it is, do retirement accounts get counted into my estate's assets and go into probate if I only have a will instead of a living trust?
That is a great question. Retirement is an exception to the rule. So retirement will transfer via beneficiary regardless of will or trust. So as long as you have valid, up-to-date beneficiaries, so we recommend if you're married, spouse, but make sure there are contingent beneficiaries as well. Because the problem will be if you have a retirement account and something has happened to your primary beneficiary and you did not name a secondary, it can wind up in the court if you didn't have a trust saying where it would otherwise go. So that's the biggest caveat with any beneficiary designated account is it's a great way to avoid probate on its face, but you need to make sure you've got contingencies built in or kept updated.
Kate is very happy to see some pet planning on the list, as I'm sure
Love our pets.
you and Zach are too. There is a question in regards to your rates or fees for your services. Can you speak to that?
It will depend on the package you ultimately choose. We can have packages as low as $1,550 up to $10,000. It is a very wide scope because it depends on the family. But what I will say is at the end of the consultation, we will provide you a precise quote so that you know, is this something you want to move forward with or not? So again, it's a very wide range, but we will absolutely be able to narrow that down in the consultation. You're not obligated to move forward until a fee agreement is signed at that point. So if I give you a quote and you go, I need to think about it, that's fine also.
And following on from that, do you offer a flat fee trust and will? Okay.
All of our services on estate planning are flat fee. So it includes our time, notarization of the documents, finalizing the documents. You get your original and an electronic version. So the fee or the cost that is quoted at the beginning is the fee. You're not going to be hit with hidden bills during the process.
And if you name your adult child in a trust and then they get divorced and return to their maiden names, does the trust need to be updated with some change?
Not need, so long as they have the document showing what their name was that coincides with the trust to what it is now. That unfortunately happens all the time, but as long as they have the name change document, either marriage or divorce, that counts.
And if a house is put into a trust, is it more difficult to take a loan out on the home due to it being in a trust?
Not more difficult. There can be some, like if you're doing a reverse mortgage or a refinance, they will often take it out of the trust and then put it back in at the end of the term. But it doesn't make it more difficult to get a loan if you're buying a new house, for example, because everything with a revocable trust, we put under your social security number. So your taxes, your loan terms, all of that will remain you. So it really doesn't affect that piece of it much, if at all.
And if my AC asks, if my spouse and I have established a revocable living trust, how frequently do we have to update or will it be required to update at all?
We recommend clients see us every 3 to 5 years. Now, that does not mean people are changing it every 3 to 5 years, but if your life changes or if the law shifts in a way that applies to you, then we need to make sure your trust is updated accordingly. Fees for that can range from a couple $100 to a couple $1,000. Again, it depends on the scope. I compare it to car maintenance, basically. Do you need an oil change or do you need a new car? And then everything in between. But trusts are not required to be updated. It just, again, depends. Has your life shifted or has the law shifted in an applicable way?
Christy asks, does retirement accounts include annuity plans?
They're similar but different. Annuities typically will transfer via beneficiary as well. So they're similar from the answer I gave earlier, that it's not necessarily a probate concerned asset so long as you keep your beneficiary designations up to date.
All right. For multiple rental properties that are in other states, are there additional restrictions, costs based on where properties are located that need to be considered?
So any piece of property you have in the US, we recommend be in your trust. Now, we cannot directly prepare deeds from other states, but we work with a company who can prepare them for any state that you have property in. It just then the fee for that is based on that state's recording and processing fee. So we can take care of all of them. It's just cost is based on the state it's in.
Now, having studied law, we all know there's only two questions you ask attorneys, and that is how much do you charge per hour and how much can you get done in 1 hour? There's a lot of questions here in regards to your fees. I'm guessing that is, you're offering a free consultation and
Yes.
that could be disclosed in in
Yes.
toto in a conversation.
Exactly. So yeah, the consultation fee is waived. We don't put it on my hourly rate directly. We just do, again, a flat fee presented to you in that consultation. And like I said, it's a fairly large range depending on your assets. Do you have kids? Are you married? Is it a blended? There's so many variables. So I can really only today give a wide range. But again, consultation, there's no financial obligation, and you don't have to go forward if the fee is something outside the scope of what you're looking for at this point.
Then Philip asks, does a trust make filing taxes more difficult or complex?
No, because again, it's under your social. So nothing changes. The IRS really doesn't even care that you have a trust at that point.
Andrew asks, when you say update a trust when your life changes, what are some examples
Yep.
of life changes that should trigger an update?
If you were single and now are married, if you were married and now divorced, if you had minors that are now adults, if you're planning to move out of or into the state, most people are moving out of, not into California, but moving can be a big one. Those are the main, though, that we see where if your familial circumstances are shifting, that's often a big one we want to make sure gets addressed.
Araceli has a question here. If I have a trust that originally included one residence, but I have since sold that residence, can the trust still apply to a new residence?
Absolutely. So asset changes are easy for the most part once you have a trust. You can buy, sell, get rid of, open, close. The biggest thing you want to make sure is, especially when you're acquiring new property, whether that's a piece of property or a bank account, you tell the title company or the financial institution that you have a trust so that they can title things under your existing document. But it's something we can help you with, but that's not a problem. It can absolutely apply to any assets that adjust over your lifetime.
Excellent. William wants to know, do you have any attorney on staff that can speak Mandarin for a consultation?
We unfortunately don't. We have Spanish-speaking attorneys and paralegals. We do not have Mandarin, though, at this time. If you have a translator who can attend the appointment, that is fine, as long as it's somebody who doesn't necessarily have a financial interest in what is being translated, but no attorney on staff that speaks Mandarin.
And then I have a question here from Jennifer. If bank accounts are under a POD, I think that's a TOD, transfer on death, is that enough to keep them out of probate?
Pay on death, transfer on death, it can keep it out of probate, but it's the same caveat as retirement and annuities. Make sure whoever it's going to is still alive, they're still competent to inherit, because again, if they become incapacitated and end up on Medi-Cal, for example, an inheritance can cost them their benefits. So with beneficiary designation, it's a great way to just avoid probate. It's not always the best option for contingency planning, though.
All right. There's another question here. Do beneficiaries for non-retirement accounts with banks and/or financial institutions work, or they have to be in a trust?
Same answer. The trust provides contingent planning that, again, death, incapacity, things like that. It allows for flexibility of circumstance. Flat beneficiary designations don't offer that same flexibility.
Excellent. And then if you are the beneficiary of a trust and you are concerned about how things are being distributed, do you give consultations for that, and would you represent the beneficiary in court if that is needed?
Yes, that is where Elaine Alston in our litigation department comes into play. So absolutely, we can do that.
Okay, there's a controversial question here, and I'm going to throw it at you because you can handle it. It says, I see some mixed reviews about your firm. Just curious about additional fees for any future updates that may be minor or major. How does it work and costs associated with it? Thanks.
Reviews, what I will say is unhappy people write reviews, happy people are less likely. So that does, unfortunately, it affects us like anybody else. Most of the time, the reviews we have received about fees, frankly, have to do with administration costs, which are on an hourly basis. I think there's a perception for people after someone dies that the cost really won't apply. But unfortunately, administration costs can be exorbitant depending on the complexity of an estate plan. So, I would argue, of the reviews, at least that I've seen of cost, that's typically where people are the most upset. Either way, with the estate planning side, fees are, like I said, presented up front. They can, going forward after a plan has been established, if it's asset changes, those are typically $0. If you're having a substantive life change, you got married, you've got kids now, we're basically redoing it, then you're back in the thousands range. But again, compare it to your car maintenance. Do you need an oil change that's a couple $100? Or do you need, you've hit 100,000 and you need a full, basically, maintenance update? It's really scoped based on that. But again, we present it up front, and we don't want to do anything hidden so that you're not expecting the fee as the time goes on.
Appreciate the transparency. I guess price is what you pay, but value is what you get, right?
Pretty much. And again, estate planning, you can find cheap, but I use cheap very intentionally. Cheap is not quality. And so, unfortunately, that can have some price sticker shock for people because you hop online and somebody's selling a whole package for $800. Well, I basically guarantee you're not working with an attorney. You will have quality cut. And in most of those cases, we end up probating those estates. So yeah, you did 800 today, but it's going to cost that 50,000 ultimately, if not more. So it is why price is a tough one here, because there's so much online now that makes it hard.
Bobby wants to know, does moving property to a trust change the property taxes, old tax rates?
Not if it's you as the original owner into a trust for your benefit or for a spouse's benefit. So as long as you're the owner, you shouldn't have any tax change.
Okay. Can you name your trust as a beneficiary, or does it need to be a specific person?
You can name a trust, but I'm going to make a huge caveat to this. It has to have valid legal language, especially in regards to retirement accounts. So if you don't already know, your retirement accounts from an inheritance standpoint are under the Secure Act. What that means is your beneficiaries, other than your spouse, essentially only have 10 years to withdraw the entirety of the retirement account. If you put your trust on there and your trust does not have legal language that complies with that 10-year rule, it will trigger a one-time tax. If you do have a trust with the right legal language and you have a financial advisor who understands trusts, then yes. But that is a huge caveat that I recommend before proceeding, whether it's us or another attorney, have that reviewed, or there could be a big issue for retirement accounts specifically.
Very good. And is that free consultation that you mentioned, William wants to know if that's offered to everyone?
Anyone who's on this call. So with our education events, we offer the free consultations. If you're calling us cold, so to speak, and you have not attended, there's typically a fee. But one of the advantages of attending our education events is it then allows you to waive the fee. The reason being is the education typically is the foundation part that gives you information of, do you even want a consultation? So for anybody on this call, if you're hearing me right now, you watch something online of ours later, just let us know how you found us, and it would waive that fee.
All right, thank you. And when they call through, just a follow-up to that question, should they mention that they're CEMA members? I'm guessing they should.
Yes, I'm going to let my team know. So we have an entire department that does our intake. I will let them know if you mentioned CEMA, or even you attended something with Victoria today, even if you're general, it will trigger that you can get that consultation.
All right. Cassandra Gonzalez wants to know, what do you recommend you name your trust? Is there like a nomenclature or protocol?
Typically, it's your last name, Revocable Living Trust, but you can name it whatever you want. I've had people get very creative. It's up to you on that one.
Laura's got a question. Laura Jones, it sounds like you're willing to work with people in their current W&T and help update, improve, etc. So WT, I guess, will and trust. Can you please confirm that?
Yes, absolutely. We can review former documents and let you know what the scope of our work would then entail and any cost associated. Yeah, that's not a problem.
And then Jim Fitzgerald just wanted to make a point that annuity can be a 5-year limit.
Yeah, yes. With annuities, they're a little different again from retirement where they have the terms and everything else. So, but typically they still go by beneficiary.
Andrew Crockett once has mentioned, you were using the term living trust rather loosely in the presentation. Andrew
Mhm.
wants to clarify, how is the concept connected to the terms revocable versus non-revocable trust, which I have encountered when researching trust in my own life?
Revocable is more tied to living trust. The idea with revocable is you can revoke it, you can change it. The irrevocable or non revocable, in almost all circumstances, once you set it up, you cannot change it. The other issue with non revocable is you often lose any benefit and control. So some people are concerned about lawsuit protection, for example. And so they're wanting to preserve their financial practice, their law practice, their medical practice from lawsuit, but you lose a lot of control and benefit. Revocable is more what we're going to talk about with most people, unless, again, they're concerned about advanced liability protection.
And Diana De Los Santos asks, can we bring our spouse to the free consultation?
Please do. We actually prefer that both parties who need to make the decision are involved, and we don't charge just because you attended and your spouse didn't. That's fine. You can both still attend for no charge.
Christine Vo asks, can a trust be updated with a law firm in a different state, or will it have to be recreated in that state? I'm guessing this pertains to real estate that you may own in different states.
So, or if you're moving.
Or if
So,
you
one of
move,
the big
right.
issues we see is people, or questions we see. They set up a trust with us in California. Now they're moving to Nevada. Now, the great news is your trust is still valid in the state you move. Depending on the state, we might recommend you meet with someone specifically there. But as long as we establish the relationship, the attorney client relationship in California for estate planning, we can continue representing you and your trust, even if you've moved out of the state. But again, we have to have started the relationship here.
And just a follow-on question to that, if you own real estate in another state and you are a resident in, say, California, would you need two different trusts, or would you need a separate will?
Not necessarily. Most people do it all under the one we create or that they have.
All right. Mary Beth Rogers asks, is there a legal issue with just having other people have our passwords to accounts, our phone, etc., rather than a legacy contact?
That's a personal preference. Anytime you give your personal info out, you are upping the risk of somebody losing it, hacking it, accidentally leaving it somewhere for someone else to find. So the reason I love the legacy contact is if I died, my husband then can literally go to Apple, they can verify his identity, and then he gets my information. But I'm not, and you can set backups. I'm not super fond of giving personal info out, especially with how often things can be hacked and everything else. But it's 100% personal preference on that one.
I think that's all the questions we have at this time.
Perfect.
Oh, wait, we have one more question just popped in. Um, Carla Collins, it says, hi everyone, big thanks to Jose Luis Pacheco for joining us. And he's going to be taking the mic here in about 5 minutes. I just want to say thank you once again, Victoria. Thank you for CEMA for allowing us a bit of your time. I hope that this has been beneficial and productive. I'm sure that there will be further questions, and Victoria and Drew, and Zachary, and myself, we're here for you guys. I hope that this has been valuable, and I certainly look forward to spending some time with you guys again and answering more of your financial planning and estate planning questions.
Thank you, Alex and team. Thank you very much, Victoria, for that presentation. We're getting a lot of really great positive comments, so it's wonderful to see, and this will definitely lead us to more of these with your company for sure, because there's definitely a lot of interest.
Well, thank you. Thank you for having me.
I have to laugh about you saying that people only comment when they're not happy. It's like when you go to a restaurant, you forget to tell them what a great waiter or waitress you had, unless it's crummy service, right?
Exactly.
So that's very true. Very,
It's
very
sadly true, and we definitely combat that. It's part of the game.
Right? It is what it is for sure. So, Luis, Carla, would you like to introduce Luis?
As Carla looks for her unmute button, I'd just like to say we're joined today by Jose Luis Pacheco, so please do not leave yet. The recording this was recorded and it will be uploaded this evening to YouTube for everyone's benefit, and that will go out in the next voice for people that do want to consult the excellent presentation by Victoria and Alex, sponsored by the PD event. Thank you, Robin, and to the whole PD team. Luis, you're going to be on in just a second. And just as everybody's reminder, because the theme of this is, wills and trust, I put that in the category of financial well-being. Another big aspect of financial well-being is CalPERS, which has an incredible amount to do with your financial health when you retire from the public system. With that, Mr. Pacheco, would you take us away? And you have 5 minutes, sir.
Thank you very much, Andrew, and I really appreciate it. And I also really appreciate everything you've done here on this wills. And I just want to make sure that everybody knows that at CalPERS we have the special power attorney form. Everybody should have that filed on. That's really important in the event that you become incapacitated, that you are able to have that. It's very special. It's a special type of form. That's different from the wills and trust ones. So please make sure you get that or contact me. Well, first of all, thank you so much, Andrew, for letting me join you all. As you all know, right now, the election is going, and it's going now. We started the election on August 29th. The ballots have already been mailed out. The blue ballots have already been mailed out, and it is going. And we have it's been an incredible experience. I've been going to talk to a lot of folks, going out with the GOTV outreach with a lot of the folks, making sure that they know about the blue ballot, making sure they fill it out. There are different ways of doing it. You can do it by mail with the blue ballot. You fill out the form and you sign it. Make sure you sign it and then drop it off in the mailbox. You can either also call in or you can vote online. So those are the 3 major things. And I just want to thank everybody for allowing me the opportunity, and also to be I'm very humbled and privileged to have your endorsement with CEMA, as well as the Operating Engineers Local 3. For me, being on the CalPERS board is very personal. I come from humble roots. I'm from Pajaro Valley. I grew up there. My parents were farm workers, and my mom was able to become a telephone worker and became a member of CWA, the Communication Workers of America. And I became a union member with CSCA at the San Jose Evergreen Community College District, and I've been there for a long time, and I've been a union leader since then. So it's been an incredible journey, and I want to continue the journey to make sure that I defend your benefits with responsibility and transparency and independence, because that's really important to make sure that I are there. As you may know, we did really well this year with our investments, 11.6%. We increased our funded status to 79%. I want to continue that going. We also made sure that I made sure that we had a robust language for the new PPO plan, and also for the CVS Caremark. So now, for the first time ever, we don't those vendors now have a skin in the game in terms of economic incentives to curb the rising care costs associated with medicine. So that's really important. So we're doing a lot of good things, and we're also doing a lot of great things for next week when we do the new analysis of our total portfolio approach. So thank you. I wanted to bring that up to your attention, and I want to open up to questions because I know I have very limited time, but I want to make sure I can answer anybody's questions.
We're actually at time right now, Luis, but there was a question. Somebody asked, how long does it take when you fill out the power of attorney form for it to be updated at CalPERS?
Oh my God, it takes only about 15, 20 minutes to do. You can actually you can actually have the CalPERS people do it for you. You can call the CalPERS office, and they can walk you through the process, so forth. So it's really easy, and there's an online version of it, I believe, and there's also a paper version. So you can or you can just email me, and I can also send you the information.
Thank you.
There was one question as well, Jose, which was about the CalPERS special power of attorney form. You said that was available online. So I think
Yes, sir. Yes, sir. It's online on in the website under forms and publications.
thank you. Forms and publication.
So make sure everybody votes. Everybody, please vote. It's critical now ever. Right now is the sweet spot.
And that should be in people's mailbox. Is that correct, Jose?
Yeah, absolutely. And
Yeah.
you guys can also look up for some more information by going to my website at www.pachecoforcalpers.com. www.pachecoforcalpers.com.
All right. Thank you very much. There's no more questions. Everybody should have the information. This was and is being recorded, and it will be uploaded this evening. If you have any more questions, you have the information to get a hold of either Luis or Alex and Victoria. So if there's no more questions, that's it. I thank everybody for attending. Sorry, I'm wearing a blanket, but my office is freezing. I'm sorry.
No.
They can't. They can't fix it. I don't even know it. But anyway, thank you again, everybody, for attending. And Alex, we look forward to another session with you and your team.
And Robin, your committee got some great kudos. So thank you, everybody who presented, and good job to the PD event. You guys have really done it.
Thank you, everybody. Have a good day. Bye.
Thank you.
Recording ends.